Mr. Miller, what's your initial comment?
My initial comment is my client has gone through this for 2.5 years at huge cost to the taxpayers, him personally, from what I believe was a false allegation motivated by financial interest. And at the core, at one level, I'm disappointed because the media was able to report on some allegations, and the day I was to cross-examine the complainant and reveal what I can clearly show are multiple instances of deceit, deception, and extortion, that opportunity is denied to us. The Crown has the right to withdraw the charge, but one wouldn't argue with that, to have it removed when the Crown withdraws it, but it's disappointing not to have the ability to get the truth out and to answer to the claims that have haunted this man since the October 15th leak that put him in a category of people that he had no business being placed in.
Why not oppose the request then so that it comes out?
It's never been done and it wouldn't be done. I used to be a prosecutor. Prosecutors can withdraw charges.
Okay.
They can't be forced to go ahead. So it would have been a fake fight, right? But, I spent the whole weekend, every minute getting ready and had 52 pages of cross-examination. But it's also disappointing because I was looking forward to the Chief of Defense Staff taking the stand and asking him about political interference with the investigation and how this was handled. Part of me can't help but wonder, how enthusiastic he was about Chemical. But I don't know what goes on behind the scenes. What I do know is that this could be a turning point in how the military approaches these things, because they have eviscerated the chain of command and allowed allegations to be weaponized in many cases without investigative journalism, and especially in this case, without a proper military police investigation. It is the worst investigation I have ever seen when I read the disclosure on this case. I've never seen anything like it in my life. And I can assure you that there will be a litigation arising out of this that will hold people accountable.
Like a civil suit, you mean?
Yeah, a civil suit.
From like a lawsuit from your client to the government.
The government and anybody who participated in the destruction of his career without doing their duty to investigate. And that will be coming shortly.
And can you clarify, because we didn't hear your case in court, in particular, what role you believe the Chief of Defense Staff had in the investigation and in this case, and what was improper about it?
Well, it stems from what I believe is Lieutenant General Jenny Kerrigan, he's the Chief of Protocol and Standards or something like that, who has said that she's adopted this position of we must believe all victims, and how that affected the decision-making of the Chief of Defense Staff to relieve him from command once it became public. I think the military has to take a hard look at how they're addressing justice and due process, and not just be reactive to media stories and aiming to please the government. They have a duty to protect the nation, which means protect the resources that are crucial to its defense. Lieutenant General Whelan was one of Canada's top generals and one of the people who was going to help the military. And the military finds itself in an incredible crisis, I think, because of a lack of courage from senior leaders to do what was right, even if it was unpopular in the media.
But tell me how you and your father are feeling right now.
I had an incredible adrenaline dump because I was ready to cross-examine the complainant. Like every fiber of my body was ready to hold her accountable for her lies. And as much as I would have liked being in that center stage and showing great lawyering, I'm overwhelmed by just the sense of relief and emotion that this man can get on with his life, knowing how much he's been through. And so, some tears of joy, happiness, but unexpected Monday morning, like really.
I just was hoping on the Chief of Defense Staff, what was improper in the conduct that you saw?
Well, I think you guys touched on it a little bit, in that for 4 months it was okay for him to stay in his job. And the Chief of Defense Staff, when the investigation happened, General Whelan called the Chief of Defense Staff when he found out about it, and he offered to resign. And the Chief of Defense Staff said, "You don't have to resign, there's nothing there." And then you have this leaking going on. or when the leak happened, all of a sudden he is removed from command. So if there was nothing there, why do you get removed from command when it gets into the media? Like, it's not in the interest of justice. It might be to appease something, but if the chief of defense staff thought there was nothing there and he could stay there, why did it happen there? In addition, the complainant was so manipulative in terms of using other people. She was communicating directly with the vice chief of defense staff and the chief of defense staff or his staff about this case. And so you have to think, when an investigation is ongoing, going above the chain of command and talking to them about what's happening while the police are trying to do their investigation is completely inappropriate by any standard of law. And so why were you talking to the complainant, right, when an investigation is ongoing? And I'll tell you why. It's because they report directly to the deputy minister's office, which tells the prime minister's office how dangerous is this case. And so we're existing in a justice system where an investigation is ongoing, but the chain of command is talking to the complainant so that they can tell the prime minister's office how dangerous this is in a scandal. And that is an abomination of justice. And they should have stayed right out of it. But the desire to please the political masters interfere with an investigation, and we're going to hold everybody who was part of this accountable in a civil lawsuit.
And in particular with the police investigation, just going back to the resignation offer. So when did your client make the offer to resign?
When he found out there was an investigation.
And when was that?
That was right in the middle of the election between Trudeau and O'Toole. So it looks very clearly like the prime minister's office didn't want another story because it could have affected the election. And that is interesting. And that's something we should look at because that's not the right way to do things.
Okay. And then on the police investigation, what in particular was wrong with the police investigation?
I can tell you that I have hired and had an expert report that was going to be called from a former NIS officer who was in professional standards, meaning he was the person who reviewed it, and his 32-page report that would have been entered into court was an absolute scathing account of what was happening. If any rule of an investigation could be broken, it was broken. It starts from Corporal Taylor telling the complainant at the first interview, we're on the same team. Police officers are not on any teams. Police officers have a duty to investigate. It moves into the incredible, and it came out in the motion, that they allowed a complainant to take 3 months to provide documentary evidence in terms of the emails that she said she had. Police officers have to secure the evidence and control it to make sure it's authenticated. She said, I'll bring you emails, and then 3 weeks later, the investigators say, are you bringing these emails? You still want to go forward? And then she delivers the emails that she chose to deliver. Not the complete record. That's unheard of in policing. And if any police officer is listening to this, they'll shake their head, or any crown prosecutor will shake their head that you would allow something as important as that to be delivered. The police are not agents of complainants. The media should not be agents of complainants, right?
Do you mean in that the police didn't do their own production order and search for servers, that they just took what she offered them? Is that what the distinction you're making?
That's an element of it. There was direction to do a production order, but it was never effective. And if you want to ensure the reliability of these communications, the police have a duty to investigate. And there were so many inconsistencies in her statements that I've been able to pick up. There was 56 officers on this case. Never have there been 56 officers investigating one case that I've ever heard of. 3 of them withdrew because I don't think they liked the case or because of threats from the complainant. I had two of the prosecutors withdrew from this case. It is a gong show of gigantic proportions. And I think the reason why the investigation was so poor is because they were terrified of the political ramifications from the police officers saying there is nothing here. And that's why the charge ultimately was given to them by the director of military prosecution. The police officers didn't come up with the charge. They were told by the director of military prosecution to go ahead with these 2 bogus 129 cases.
Can you explain
Explain what?
the difference between the police recommending the charge and the military prosecutor directing them?
The military justice system is a little different. In civilian police agencies, the police officer has the sole discretion to lay a charge, not the Crown Attorney's office. They just take the charge, right? Within the military system, the JAG prosecutor can have some influence, but the disclosure that we had received showed that no police officer was recommending a charge. And then the only disclosure we got was that they had received the charge wording from the director of military prosecution to go ahead. And the person who authored that charge was a captain who was inserted in at the last second and had no familiarity with the charge. So a military police officer who laid it took the wording from the prosecution office and charged it and had no understanding of the case. And that's why it's been a gong show from the start.
Do you feel that without being able to do the cross-examination and without being able to lay out the case that you wanted to lay out, that this conclusion is satisfactory?
It's satisfactory from my client's perspective, because I can tell you that to me, there's nothing more indictable than having the charge withdrawn mid-witness of the main complainant. Like, this just does not happen that often, the judge says. So it tells you that something was going on there that shows that there's no case. I don't understand how it was discovered over the weekend, but that's not my prerogative. But I'm saying it's not over, because I have prepared all of the foundations for the civil suit that is going to bring this man justice.
And just to clarify, though, I mean, now you're in a position where there are emails that will be released because the case is over, the voir dire publication ban ends, that you yourself have said are prejudicial and embarrassing to your client. So how do you explain those emails and then not showing something inappropriate?
This is where I would maybe idealistically believe that the media might do some investigative commentary that says if somebody had 3 weeks to deliver only the emails, that's wrong. You have a lot of emails. Clearly, I haven't seen a headline that says it sounded from Colonel Lovins that she was extorting people. That wasn't done there. You won't even publish her name. It's not a sexual assault case. His name is published. I'm coming after the media agencies that treated him unprofessionally. Her name is not published, and it is not a sexual assault question. Look, you can publish emails all you like, but if you do it without the proper qualifications.
But what is that qualification? That's what I'm asking.
Is that she edited the emails. She gave select emails. She took out the ones before and after. She never showed you 3 months of emails before where she was begging to go and sort. No, I'm saying, but like you, if I'm
which was not an argument you made in court. Just it's like, yeah, last week you didn't say that this is an illegitimate, incomplete email. You didn't.
It was said multiple times through all the applications.
Through the preliminary.
Yeah, and it would have been the first question this morning. Where are these hundreds of emails? She sent him a picture of herself. That doesn't matter per se, but these were private communications between two adults. Would they be embarrassing if you're married? Yeah, at some level, yes. Right?
How would they ruin a career then? So I guess that's what we're trying to get at is like, so. I can
tell you because I know what you're saying. If something like that was raised to a senior general, when there's a little smoke, when you're trying to get to the chief of defense staff, you can't have anything about you at that time. So something like that would just generally put you off the track of promotion because there was like this smoke raised, even though there was nothing there that was illegal. It could put you off the track, but General Whelan's main concern was about his relationship, right? And didn't want them to be put into the media, so it would cause more embarrassment to his family, and the problem is the complainant's not named. So she doesn't care what's put in the emails because her name is not there. And I think you have a positive obligation to put her name in there because these charges are withdrawn. He has been put through 2.5 years of hell. Her name is not there. She selected emails. So he is destroyed by her stories, and nobody knows how much of a liar she was.
But again, it doesn't address the question of the emails. You're saying they weren't illegal.
Yeah.
How does it not show inappropriate behavior? I'm not talking about the legal threshold. Yeah. I'm talking
Well, if you're in a committed relationship and you're texting someone,
it's about that he's a senior commander in the military.
No, he wasn't charged with that. Or I know with charged. Yeah.
But you're saying that this exonerates him completely, and that this
from the criminal charges.
The criminal charges. What I'm asking you to address is the content of the emails.
Yes.
And whether you believe there is, or your client believes there is, an explanation that makes them justifiable in the public eye. That's what I'm asking you.
Justifiable it is a spectrum, but in terms of what people do when they have private communications between friends, close friends, people they might have feelings for, but what needs to be emphasized is nothing physical ever happened between these humans. There was never, ever a request by him to see her overseas, ever. But it's embarrassing. If all of your texts were revealed, I'm sure there's some in there that would embarrass you to your parents or to your spouses or whatever it is. Like, these are private, personal, but the Canadian Forces allows personal relationships. Under DOD 50-19, one of the senior officers in the military police is married to a master corporal, right? Like, the Canadian Forces, most of the marriages are from people of different ranks. How do you develop a relationship in the Canadian Forces if you can't communicate, if you can't, so in and of itself, trying to develop a relationship isn't illegal. It can be inappropriate if you're committed to somebody else and which you're embarrassed of, but these guys get put under huge pressures. And, you know, he acknowledged that, how that affected his wife. His wife stands by him. His family stands by him. And he's going to go on and rebuild his life.
To be clear, so you're saying that the deleted emails you're saying there are missing emails that show a different exchange.
Yeah.
That would put it in a different light. That's what you're
Absolutely.
saying.
The emails that, and this will come out in a lawsuit, but just, I think it'd be nice if you qualified. These emails will show that she sought his protection. She sought him. She wanted to get out of SEFCOM. She was using him and manipulating him, and she was lying about it to everybody else. She lied to the police about having a husband. She said she only had 2 husbands. She had a third one that she was sleeping with the whole tour. He was going to testify tomorrow and say how she lied to everybody in the chain of command. When she said to you guys, oh, I was scared to go on tour, her husband was saying, her then boyfriend said, don't come on tour because we're going to end up fraternizing. We're not supposed to do that. She insisted on coming to tour, but she said there with crocodile tears, oh, I didn't know I was being, she manipulated the situation to go on a tour with her boyfriend that nobody knew about. And then she ended up moving in with him and becoming common law with him and didn't tell the police his name so they could investigate.
What is wrong with her having a relationship, though?
What do you mean?
Well, you just said her having a relationship was fine in the military. So what is nefarious about her having this relationship?
Because there's a fraternization policy everybody has to sign. You're not allowed to have an intimate relationship while deployed overseas. He was a major, she was a sergeant, right? But she lied to everybody about it. She hid the fact that she had it on tour, because if they would have discovered on tour that was going on, she would have been court-martialed for fraternization. So she lied about it to everybody. She lied about it to the police, right? Because if you want to investigate her claims that originally went through you, maybe you want to talk to the guy who was in a room every night for the whole tour and ask him, because he was going to testify, she never, ever raised any issue with Whelan on the tour. She never told her boyfriend that she was intimate with the whole tour, that she had an issue with General Whelan, that he made any advances, nothing like that. Like, this is just, police need that information so they can go interview. They never had that information. That's a negligence on their part, that they didn't find out what this name was. And you have a duty to help the police in investigation by telling them every witness who could help your claim. But if you're making an allegation, you want to protect yourself, or you don't want them to discover what your real motivation is, you withhold the name of the most important witness, probably in this case, which would have been him. And she withheld that and pretended like she didn't even have a relationship with this guy.
So is there assertion that nothing inappropriate could have happened between the complainant and Lieutenant General Whelan because there was something else inappropriate happening somewhere else?
I don't understand my question.
Well, you seem to be saying that because she had a different relationship,
Are you asking me about possibilities?
No, I'm asking you.
It's possible anything could happen.
No, I'm asking you if you're essentially suggesting that her sex life discredits her from having a legitimate complaint about sex conduct.
That's a trope. Because you do not deny the police the ability to interview crucial witnesses unless you're lying. I'm not saying that your sex life affects it. That's bananas. But when you deliberately deny crucial witnesses to the investigators, there is a negative inference that rationally minded people should create from that.
And in court, you said that could you just speak a bit more about the impact this had on the general? You said, I think, in court there were protests at his house. You said his wife stands beside him. Can you just
when you leaked that story from her, even though you said you didn't have authorization to do it, and I was going to ask her if she gave you authorization to leak the story to the Globe and Mail, because there's a recording I was going to play today of her threatening the police that if they didn't lay a charge or remove him, they were going to the media, and they had just spoke to the media in the morning. When that story went out and you grouped him with a bunch of other officers who were charged with sexual assault, he got put into a category that's impossible for him to rehabilitate. There was never a charge in that area, but he was immediately removed from command, as the judge said. People came by his house and started yelling at his house. He lives way outside of town. It just destroyed his family, who suffered. He suffered personally. I don't like to ask me to describe it. I think it'd be better to put yourself in the shoes. If somebody put your name in the Toronto Star, that you were sexually abusing kids or something. Like, imagine what's the damage. It's not hard to figure out what the damage is that you can't answer it, right? It's been 2.5 years, and to have the charges withdrawn, drip, all the damage is done. Nobody is accountable. Nobody hears what's happened. And is this a casualty that perhaps you're okay with? But if they can do this to a general, imagine what they could do to a corporal, where an allegation comes up that might be motivated. That could be wrong in anything. So the whole thing is horrific. But we're glad that it's on there.
Thinking about next steps, in a case of Danny Fulton, never the middle trying its way back, in Keelan's position. Do you have any indication of what happens there?
So the same question. There was somebody in the courtroom who I believe was reporting directly to the vice chief or the chief, who was taking all the notes. I believe they're probably trying to create a paper trail to release him so they can bury him. That's my understanding. General Whelan would have been a fantastic chief of defense staff. You don't see any other complaints about him anywhere. Nobody has come up with anything. He's one of the good guys who could have helped fix the military, and we've lost him. So how does he go back when his own chain of command betrayed him in many ways? Difficult. We anticipate that they're probably going to try to remove him, and I will be aggressively starting a civil litigation to deal with the injustice of the military.
Hasn't he already been removed? Sorry, just to clarify that.
So he was removed from his command position of Chief of Military Personnel, but it doesn't mean kicked out of the force. But what you would have heard today is the chain of events for Dana Mills. I just want to tell it to you, and it might not even get on. She worked for him in 2018. She got news that she was going to be released in 16 months, February 2020. She came to his office, this woman who said she had no power, wrote that date on his board and said, "Prevent me from being released." And he couldn't do it. And so when he ended up going to be through deputy CMP, she was concerned because her release, when she was going to be released February of 2020, January of 2020 is when she went and did an HISB complaint. So 1 month before her being kicked out of the Army, she goes and puts in a complaint saying that she suffered from sexually hostile environment. You can do that, that's fine. It just so happens it happened 1 month before she was going to get kicked out, and she got another extension. When you put in that complaint, that release goes to the CDS and it goes through the CMP. Now, on March 21st, 2021, she was talking to her release personnel and said, "I'm not going to make a complaint to the police." I got that document. On May 14th of 2021, General Whelan was announced that he was going to be the CMP. And that meant that he was going to see her release paperwork, right? 4 days later, she called the police. And then when he wasn't being charged, and he wasn't...
What's your point there with that timeline?
The point there is that she was worried he was going to interfere with her release. Her going to the police was 4 days after he was announced CMP, and her going to you, Marika, was because she was worried that him as the CMP could affect her release, her finances, and that's why she leaked it. because that's what got him out of the way of him getting in the way of her release. It is a very clear timeline of showing how people can use the system and use the media to affect the destruction of people in order to protect their financial interests.
I'm just trying to understand. Sorry, when you say interfere with her release, so he's going to make her be released or prevent it. I'm good with.
I know what you're
released already.
When you go under she's still in the forces.
No, I know, but you said that the complaint came after he became CMP.
Yes.
But how could he? Wasn't any interference from him would be to not release her? What you're saying is what she wanted.
I believe because he wasn't able to help her extend her release in 2018-19, that she was concerned that he would call BS on some of the details in her release paperwork, right? When you do that release, it has to go to the HISB releases have to go to the Chief of Defense Staff. They don't go through DMCA. It's a different avenue. The CMP is the adjutant to the Chief of Defense Staff. He sees all the paperwork. Now, what she ridiculously didn't understand is that he would have done anything to help her. Like he would have helped her in any way that he could have. But I think in her brain she thought, he's going to see this paperwork, he's going to screw me all over, and so she dusted him 4 days after it was announced. And it was a deliberate takedown. And all of her statements that I was going to cross-examine her on today, you would have seen the steps and the lies.
Thank you so much.
You're welcome.
Can you share the